request bail in the amount of $250 on the basis that this was could have been a criminal trespass.
Court, they look and sound just like any other defense lawyer. In fact, you might not know there was a difference unless you've got to look at their caseload or their paychecks. They're the state's public defenders, and they're on the docket for this edition of Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.
They're the lawyers for those among the accused who can't afford to hire a lawyer, the ones the state pays to provide defense for the poor. I'm Ray Brown, and on our docket for this due process, the public defender. We'll talk to one county's chief PD and the chair of the New Jersey Senate's Law and Public Safety Committee. But first, here's Sandra King with some perspective on how the public defender came to be and just what it is they do.
Ray, we know it as a basic constitutional right. You're accused of a crime, you're entitled to a lawyer. But that wasn't always the case in this country. In fact, it wasn't until 1962, and the case of a 51-year-old petty thief from Florida who petitioned the Supreme Court in a pencil-written appeal, that the right to counsel at last became law. Once the court made its ruling in Gideon versus Wainwright, you no longer needed to afford a lawyer to have a lawyer. Enter, then, the public defender. Here in New Jersey, they now handle 85% of all criminal cases. PDs like the ones we caught up with in Hudson and Morris and Essex.
I believe we have a Mr. Edwin Rosario Negron. On Mr. Negron's behalf, I will acknowledge the receipt of a copy of complaints. I will waive any formal reading of those complaints and request that the court enter a not guilty plea on his behalf.
She may enter as many as 100 pleas in just this week alone, because this is the court where defendants are arraigned, where bails are set, where the charge can be dismissed or the ante can be upped.
That is where you should land $15,000 on them.
Thank you, Judge.
And for the vast majority of defendants here, this initial defense will come courtesy of the state, from public defenders like Deanna Starr.
There are no indictable convictions. In light of the downgrade, we're requesting a cash bail of $250.
I come in here at 7 o'clock in the morning into this court, and I set up all the paperwork for the people that we'll be seeing during the course of the day. I read the documents, make sure that we have all the documents for all of the prisoners, make sure they're eligible for a public defender as determined by the criminal case management.
Everyone has a right to find out what their charges are and to find out from the very beginning so that you can set up a good defense.
And the defense that starts here will continue through trial, or more often plea. And though the face will change, the next lawyer too will be a public defender. A public defender who may be juggling 24 or more other cases.
You're preparing trials, you're dealing with motions, and all the other things that come up, investigations, and sometimes it can get a little stressful, especially when you're doing one trial after another without a break in between to kind of catch your breath.
Time constraints are significant, largely because of our caseload, which is more than what an average attorney, unless he's specializing and doing high-volume criminal work, would come in contact with.
We're simply overworked. It's not that we are not doing our job. It's not that we're not doing an effective job. It's just that we are swamped.
In fact, 85% of all indicted defendants depend on fewer than 350 public defenders, with annual salaries that range from less than $40,000 to nearly $90,000, and a combined yearly caseload of 125,000 clients. And though the policy of this state-funded, state-run office is don't complain about too great a caseload or too small a budget, Ask the rank and file what they're up against, and sometimes they'll tell you.
The resources haven't kept pace with the volume. I've been a public defender for 22 years. The major change is the tremendous explosion in the number of cases coming through the office.
It's almost guerrilla litigation. You don't receive, well, you don't have necessarily the resources that some major law firm may have. However, you do have some resources, but nowhere near what the law enforcement side of the case would have.
In fact, even Trenton will concede that its public defender staff's outnumbered 4-to-1 by the prosecution.
This defendant has 10 arrests resulting in 5 indictable convictions.
But PDs are up against more than that.
I mean, they don't maybe put as much time into the case, just because, well, they're a public defender not getting paid as much.
They don't care whether you get screwed or not.
They get paid anyway, whether they lose the case or the win. I don't think it really matters for them.
Still, the PDs insist that the public perception of second-class service is simply undeserved.
There being a presumption of incarceration on this sort of offense. We provide them with the same services as a private attorney would provide, and they deserve the right to a fair trial. We give them that.
Sometimes what we do is not very popular, but it's very important.
We have a pretty committed group, and I would be inclined to think that we do well with what we have. Not to say we can't use more.
But however imperfect the PD system may be, compare it again to the way things worked before Clarence Earl Gideon won his precedent-setting case. Before the Sixth Amendment's right to counsel or the 14th Amendment's right to due process finally came to mean the right to counsel for all, whether or not they could pay the tab. And even after Gideon versus Wainwright, it was, as you know, Ray, a very long leap to an organized system of public defenders, decently paid and doing a decent job for their clients.
What's intriguing, Sandy, is that we know, at least in part from interviews done for this show, is that members of the public have very strong opinions about the public defender, mostly negative, but seem to know very little about how the system works.
We went to a shopping mall in Jersey City, and you saw a little bit of the response that we got. You'll see more in the man on the street, or man in the mall in this case, package that's about to run. I have to tell you, we did not find a single person who had a positive perception, correct or not, of the public defender.
Maybe Brenda Smith and Senator Costco can help us straighten that out.
Indeed.
And when we come back, we'll talk to a state legislator who helps set legal policy in New Jersey and to a public defender who helps carry it out. Stay with us.
I think everyone is entitled to a lawyer because the lawyer will fight for him.
Everyone that wants one gets a lawyer, but not the best lawyer. Just like the O.J. Simpson case tell you, if you have enough money, you get a better lawyer.
Public defenders, they see this every day, you know what I'm saying? There's not really a one-on-one basis with their client.
I think it's more of a job on behalf of the public defender, and I think he has his set salary and he's going to do just what is needed to be done.
Money talks, and you pay enough money, you can get off.
They are attorneys, but I think money talks. If you have a private attorney, you get better representation.
The public perception does seem to be that the public defender just won't do the job that a private attorney is able to do, that they don't have the time or the talent or the will. But is that public perception just another prejudice, or is there an element of truth behind the image? For some answers, we turn to Brenda Smith, Chief Public Defender in Somerset County, and State Senator Louis Costco, a Bergen County Republican who chairs the Committee on Law and Public Safety. Welcome. Brenda, let me turn to you first, and let me share an experience I had when I was a baby lawyer more than 20 years ago. I remember interviewing a young man in prison, and for legal purposes, I needed to know whether he had previously been represented by a lawyer, and he kept insisting he had not had a lawyer. When I went back and looked at the records, it turned out that he'd been represented by a public defender. He didn't consider public defenders to be lawyers, and that's an experience that I've had over time, and I think you heard Sandy's comments about the public perception. Why is there the perception that public defenders aren't real lawyers or won't provide quality representation?
Well, the average person who is represented by our office doesn't see all the work that goes into representing them. Unfortunately, their perception is just what they see. They get to see a lawyer not very much time ahead of their case. They get to see a lawyer much fewer times than they would expect a private attorney would give them. But the reality is that there's much time, there's much talent, there's much education, and there's most of all the motivation and the skill to do the job and the commitment.
So it's your feeling that most folks don't get a chance to see what public defenders actually do?
Actually do.
But isn't it also true that they wouldn't see what private lawyers do? Because there seems to be a perception that private lawyers, without distinguishing them, are better, and public defenders are not, when there's an argument that public defenders are highly specialized people who do this exclusively. Why is there that public view that somehow public defenders aren't real lawyers?
Well, you know, because of the number of cases that we handle, we don't do business in big private offices that have nice plush carpeting. We do business usually, and we come to see them in a facility. We usually have to see several people at one time, so they may not get the one-on-one attention that they would attribute being a hot-shot lawyer would get. Sometimes, frequently, in a courthouse situation, that the public defenders don't seem to get the same respect from others around them.
I mean,
so
judges,
there's some judges and prosecutors and everything. So they don't see that they're getting the high-quality representation from their public defenders as they're getting from the private
I can sense the senator wants
I think there's an educational process that has to take place. And what we have to do is explain to the public from time to time that because someone is a corporate attorney and works for a very large corporation, they've chose that as their profession. They're an attorney. They went to work for a very large corporation and they're salaried. Now, does that mean that they're not doing their job well for that large corporation? I don't think it does. On the same token, if we happen to have a large corporation, and in this particular case it's called the state of New Jersey, and we're mandated by the state by law to provide legal services so that, and the purpose of it is so that an innocent person does not become incarcerated. And I think that an attorney that chooses to work for the state of New Jersey has to have that same amount of respect that an attorney who would choose to go to work for a very large multi-billion-dollar corporation, because this same attorney that we're talking about that is working for the state is working for a $15 billion corporation. So if you can take that into another profession, then I'm not an attorney. So let's decide that I live in a very big apartment complex. And supposing that big apartment complex has an electrician and a plumber and a landscaper that works for that garden complex, that large apartment complex. Does that mean that that electrician or that plumber or that landscaper is not as good a professional person as a person who's in their own practice or in their own business?
It sounds like,
and I think not.
It sounds like from your position of senator oversight that you're satisfied that in fact the public defender does provide good representation for its clients.
I think that what we are doing is overloading the public defender's office with cases that probably should not be there in the first place. Everyone.
You mean people are being represented by the public defender who aren't really eligible?
I think we have to tighten up the eligibility standards for those people who are going there. When we have a department, we have a department here that has about 300 some odd attorneys.
Statewide.
We have about 190 to 200 investigators. We have people who handle the appellate section, which is some 60 or 70 people that handle the appellate section. They have 125,000 clients in that law office. 125,000 a year.
So you think they've got more clients than they can handle?
I think that there's more clients than should be there. Plus, that same office hires outside attorneys, and I have no idea what that number is. There are outside attorneys that are hired by the public defender's office who do not work directly for the state, but are contracted to the state.
Well, Brenda, you're a policy-making person, County.
but
you
run that Somerset County
Yes,
office.
and I don't get the sense that the people that we represent can't afford an attorney. I get the sense that the people that we represent are indeed poor people of all classes that come through our offices. Now, we don't do the eligibility standards any longer, as you know, it's done by the courts. But it's the rare occasion that I get any sense at all that we're representing an individual that is not entitled to our services.
Do you have a sense of what the average cost would be to represent the people that you're representing, your office represents? That is, what would it cost private attorneys to represent the
Well,
folks
I know that
represent?
the private attorney charges a rate that is much in excess of what we charge. Our rates are approximately $30 per hour. That's very much less than what the private attorney charges.
And the folks you represent couldn't get, in your view, adequate representation on the outside?
Well, sometimes they're forced to go and check out to see how much money they have, what cash flow they have, and what representation they can get for the amount of cash that they have. It's frequently not very much at all, and they usually have to come back again. So those are the people who are on the periphery, that are on the borderline, that perhaps may or may not be able to. The courts have said, well, maybe you can find somebody for what you have. Frequently, it's not the case. So what private rates are much in excess of what an average person can
I think the part that bothers, the part that would bother me most, if I were in her section of the state, would be the fact that we go out there, we work very hard, we represent people and try to solve their problems, try to help them, and these are the same people who they don't appreciate it. And you saw through some of the interviews, the perception is that they're not good. They're not very good attorneys because, I mean, why would they work for the state if they were any good? I think that's a very bad perception.
I think it's an unfair perception. Well, let me come back to something. Brenda, you said earlier that even judges and prosecutors don't always show public defenders the respect you think they're entitled to.
Well,
if the perception is, if it's based on ignorance, you would think that judges and prosecutors who interact with public defenders regularly would be in a position to appreciate the quality of work.
If that's the case, I would like to see the prosecutor's office outline that and put a complaint in. Let's put a complaint into the State Attorney General's office and say, we have judges that are not treating our public defenders properly.
You know,
and if they're not being treated properly, then I think that they should be reprimanded.
When you're in a courtroom day after day after day, and you have case after case after case, frequently, not only the clients, but the individuals involved in the system forget what work that has to be done. There are times when we have to fight to get out of court at 5 o'clock so that we can go back to our offices because our day does not begin at 9 and it doesn't end at 5 o'clock. There is much work that has to be done, and the perception is that we are there just to turn the cases through and through and have no work to be done, that we can go home at 5 o'clock.
Yeah, but if the
what
judge
I'm saying is even those that are in the arena forget what a hard job that is, that it's not a 9-to-5 job, that sometimes a job that carries over on weekends and carries on much
Is any of that
past.
attributable to the fact that public defenders have substantial caseloads?
Certainly it is, and certainly it is because we handle cases from arrest to final disposition, which means that we have work to do on every level. There's legal research to be done. There's interviews that must be conducted. There is law to be sought after. There's motions and briefs and legal research to be done. There's much work that has to be done in order to prepare a case. So in other words, our caseload is in constant motion. If you have 4 or 5 cases on the trial calendar in my county, and some counties it's indeed a lot more, there's a lot of work that goes into that. Making that case ready for that docket for that particular
don't you think
day.
The judges know that, and
yes, they do. But frequently, in the effort to get these cases through the court system, that sometimes they often forget that certain amount of respect, if it's attendant to that particular lawyer, that will go a long way for the client who's sitting next to him or her.
Has your office ever sent a letter to a judge and say, I don't think you treated my attorney properly? And as if a private attorney was not treated respectfully by a judge.
I don't think it's intentional on any judge's part or prosecutor's part.
Then if they're doing it unintentionally,
but I think it's all part of that rote routine that we often forget. And you must understand the public is sitting there watching all of this go by.
Well, that brings me to another issue. It's fair to say that you've sometimes been described as a political conservative. Is that a fair statement?
I would think that's very fair.
And prior to 1964, when Gideon versus Wainwright was decided, the conservative legal view was that everybody isn't entitled to counsel. That is, it's a kind of a revolutionary concept in the early 60s that we should provide at state cost representation. Are there conservatives who view now even take the view that everybody isn't entitled to representation paid for by the state?
Not that I know of. I think that this office began in, I believe, 1967 in the state of New Jersey, when we were the first in the United States to set up a centralized public defender's office, and I think that began in 1967. I don't think anybody would doubt that everyone is entitled to proper representation.
So you think the concept is firmly embedded in the warp and woof of the political?
I think the concept is firmly embedded into the minds of a constitution, and I think that that's proper. What I'm concerned about is that when these same prosecutors may try to do everything that they possibly can, and keep in mind that the charge to the public defender's office is to make sure that an innocent person is not is not good, does not get convicted.
But it's also
That's
to
the
represent
charge.
everybody, the guilty and the innocent alike.
But the charge is to show it was that an innocent person does not unfairly get convicted. That's the charge. It was also to shift the burden of cost from the counties to the state so that the counties would not handle it. These are the two main charges back in 1967. So if someone walks up to the prosecutor's office or the public defender's office and says, I am guilty, I absolutely did this, and then the public defender says, well, I don't want to accept that statement, I want to make sure that you get due process and maybe we can find a loophole that even though you did do it. Now, I'm not saying this happens, but it is
Ray,
possible.
I think it's one of proportionality. I think in your speech that you read earlier, you said that you reminded everybody that prosecutors are staffed 4 to 1 to the average public defender. Additionally, we have a situation where right now the statutes, the rules of court have been tightened a little bit, and the time within which we have to turn a case around has been narrowed. In other words, we call it the plea cutoff situation. Now, the prosecutor has a case, and they outman us. They have the case early on. They get to do all of their research. They get to do all of their investigation and bring an indictment against an individual way before we get into the case and get an opportunity for discovery and get to go. So the starting lines are not equal. Then we have a time period within which we have to get things going.
Let me come back to what I think may be a point of difference. Wouldn't you agree, Senator, that even a guilty person is entitled to, a person who says to the lawyer, I'm guilty, is entitled to vigorous representation by the public defender?
I have a question with that. If someone goes out and commits a violent crime and says, yes, I did it, and then we're going to look and see if we crossed the T's and dotted the I's, and if we legally search that person's bag to find the gun that he or she used to shoot another person, and if we found the gun... Guilty.
But the person walks into Brenda's office and says, Brenda, I'm guilty, but I want you to get me out. It's your view that that person shouldn't be represented by the public defender?
I think that, I don't know if we should spend as much time on that case as we do on a case if someone says, I did not do it.
I absolutely say that an individual has a right to a fair process no matter whether he's guilty or not, and the process will be the one that finds him guilty or innocent. He's entitled to as vigorous a representation as the Constitution requires.
The Constitution requires that a person is entitled to a speedy trial. It says absolutely...
Vigorous representation.
It says nothing about a perfect trial. And most of our problems that we have in the courts, in my opinion, is that we find these...
I would say he's entitled to the most perfect trial that he can get.
Would you actually, let me ask you this question then. Would you actually, if somebody said you run the public defender's office for a year, would you actually set up a system in which people came in, were interviewed, and those who admitted their guilt to the public defender would be treated to a lower level of representation?
I don't believe that there are 2 levels of representation.
No, but should there be?
I think that they would not be entitled to the same amount of investigation process that we do have. I don't think that an investigator who is investigating, spending his or her time investigating a person who we think is innocent, should spend any time at all investigating a case where someone who has admitted that they're guilty.
Certainly that instance doesn't happen very frequently, so we're not faced with that. But just
neither does the death penalty.
In the abstract
if I come
case
to you
where
and say I'm guilty, but I'm saying if you can find witnesses that said it was...
when we're motivated by rules of ethic and professional responsibility, notwithstanding those particular requirements, the Constitution is absolute. It's not for individuals to make judgments before they get through the criminal process. We're entitled to due process. We're entitled to a jury of their peers. We're entitled to the prosecution making the case. Every person is presumed innocent until proven guilty. If in fact it results in a guilty plea, and we know that we get plenty of guilty pleas throughout the system, but our duty, we are charged with the absolute responsibility of making sure that that system works, that that person gets every right that he's entitled to.
You're charged with the responsibility to see that an innocent person does not get convicted.
But innocence is in the hands of the jury.
Let me take it one step
further. Innocence is not ours to give out.
If you were running the office and somebody came in and they said they were innocent, but your sense from all the evidence was that they were guilty, where would they fall? Into that lesser group, or would they fall into the group that entitled to
again, I
guilty?
wouldn't set it up in 2 groups, but they would fall into the group that would, if they said they were innocent, I would then have an investigator work very hard on a case, as hard as on any. But if someone came in and said, I'm guilty, I did it, why would I go out and investigate to find a loophole why someone did something
Then that is to say, everyone who says that would have no other motivation for saying that he did it than the fact that it actually happened. Attorneys
I don't follow
are
that.
in other words, the people have motivations for saying that they did things for many reasons.
Oh, I don't
Sometimes it's to
believe that.
protect someone else,
Well,
someone they
then-
don't understand
then-
what legal guilt
then-
really is.
Oh, I don't believe that either.
Well, it's true.
Has that happened in your
differ with
experience?
you.
I don't believe so.
Certainly, people. First of all, the legal concepts are not absolute. For instance, possession.
But I think the senator says things that reflect a public perception.
I don't buy that people don't know the meaning of guilty. I mean, a puppy dog does something wrong, and before all you got to do is raise your voice, and they put their tail between their legs and walk away. Now, you're going to tell me that a puppy
certainly
dog
an
has
individual who was in an
more knowledge
altercation
than
with another individual can say that I absolutely stabbed or assaulted that person. But if I'm not to plead him guilty until I found out what all the circumstances are and see what just happened between those two individuals.
Brenda, I take it it's your view that every person is entitled to vigorous representation,
Absolutely.
regardless of what they say.
Regardless of what they say.
And that's probably one of
and
the
that's-
problems in the office.
And you
it's
see-
probably one of the problems. That
Is
even though
your view, you think, a widely shared view among citizens in New Jersey or the legislature?
I would say so. I think that people are so fed up with people who admit that they're guilty, and there's no doubt in anyone's mind that they convicted, and then suddenly...
We've gotten to the heart of some critical issues, and I wish we could spend more time talking.
Well, do it again.
Absolutely. I thank you for being here. That's it for this edition of Due Process, but we'll be back next week when our focus will be one of civil law's most controversial areas, the personal injury suit and tort reform. That's next time on Due Process. Till then, I'm Ray Brown.
We have a case.
It's like this, in many respects, it's almost guerrilla litigation. You don't receive, well, you don't have necessarily the resources that some major law firm may have. However, you do have some resources, but nowhere near what the law enforcement side of the case would have. For instance, with police and investigators and the like, we wouldn't have anywhere near those types of resources that they would have. And ultimately, it comes down to a question of rights, and so we defend the best we can with what we have.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.